Good afternoon. We are here for oral argument on Macdonald versus Macdonald. It is our number CV-25-0309. Each side has been here before, so you know you have 20 minutes each. And Mr. Berkshire, if you want to keep any time for rebuttal, you have to keep it yourself. Please proceed.
May it please the court, Keith Berkshire, attorney for the appellant, Scott Macdonald. What this case really comes down to is how this court would have appellate jurisdiction over the underlying order on the motion to amend, whether it's 1221-01A1 or is it 1221-01A2. Our position is that the only possible way is for this court to have jurisdiction is 1221-01A1, which would then require a final signed order under rule either 78B or C. Specifically in the Brummett case, the Court of Appeals dealt with all of the various provisions of 1221-01 and 1221.01 and which needed to be signed or not. Here, bluntly, Rule 78 is a massive problem in family court. The way that the trial courts deal with orders and family court never ends. It's one of the benefits of having a family law practice is these cases never go away. And there could be 5-10 petitions at the same time pending. You could have petitions filed in front of commissioners to modify child support. You could have collection actions in front of probate court on garnishments. Family court isn't civil court because of it is a never-ending process. We've had cases that literally had a pending petition of some sort for 15 years. I'm sure Justice Bean and Justice Cruz understand this as Justice Brudenell did. These cases never end, which is the reason that clarity of what is a final order and what is an appealable order matters. One of the main reasons in this is enforceability. How do you, if you have a motion to amend, let's say a case that this court denied review of 2 weeks ago, the Wachanski case, the motion to amend on that case amended the judgment to the tune of $700,000. How do I garnish that if that order on a motion to amend isn't signed under 78B or C? If I went down to probate court to try to garnish this, as we're going to do, obviously, it wouldn't be garnishable because it was on a motion to amend.
Let me, pardon me for interrupting. Let me ask a question though, from a practical standpoint. So if you had an order denying a Rule 83 motion, but it had language in there that, as you were just mentioning, that it adjusted $700,000, something in the decree. And then the question then I think you're asking that I want to return to you is, if there's no finality language in that order, how are you able to garnish the change in the amount?
Correct.
Well, wouldn't that order then have effectively amended the decree? And now you're just left then with taking whatever action you need to do with the decree. So essentially you would take that 83 order and the decree together and say, this is what I want to garnish. Why wouldn't that work?
What if the original order never had anything? I mean, it gets down to what is an amended judgment. Is an amended judgment a judgment? I mean, an amended judgment is a subset of the word judgment. It still has to be a judgment to be enforceable. And these things happen, I mean, so often. My firm obviously does our fair share of appellate consultations. I would say that the stuff that comes into my office, 30 to 50% are signed wrong by trial courts. They're either not signed at all. They're either not signed under 78B or C. They're signed under 78B that they don't say no further issue or there's no just reason for delay. I mean, obviously part of that is a training problem with the trial courts, but the reality is, specifically because 90% of family court is pro purge, there has to be some way that people know what is final. And without 78B or C, you just simply don't know what is a final judgment. And so I understand your question, Justice Montgomery, but when you go in and try to garnish the new amount, let's say the decree had nothing and you ended up getting $700,000 extra, the court still looks at that amended judgment as the order, and they're saying it's not signed under 78B or C, and they're not going to garnish on it. And that's really the issue here, is that is the final order in that specific petition. It needs to have finality. The only way to have finality is a 78B or C certification. Because, and we outlined it, I think, in the original petition for review, the way that the courts deal with motions to amend. First off, this isn't a 2101A5 motion for new trial. We got rid of, when we consolidated the rule in 2019, we got rid of motions for new trial because we don't have juries. So it's only motions to amend. So it can't be an A5 subsection. So the way the courts deal with this is a multitude of ways. They might just say one line denial, no additional findings. It is just a denial of the motion to amend. They might say, as happened in this case, a denial of the motion to amend, but with a bunch of additional findings that need to be appealable, because if they're not appealable, how can I appeal the decree? If they made all these additional findings about spousal maintenance or something else, I need to be able to appeal those or I lose the appeal on the underlying decree. They could grant the motion to amend in a one line, granted, maybe a new number put in, or they could do what happens a lot of times in family court. They grant the motion to amend with a completely struck through decree, where there is one of the cases you depublished 2 years ago, the Scogan Barber case. It was a completely struck through decree. It was like a 70-page decree that had strike throughs and highlights. Again, what do we do with that? It changed it by, I think, $10 million, if I'm not mistaken. And again, that is the final order in this case. And it said decree, it said everything on it, but that has to be the final order. And so that's really the issue here, is where is the final order in this case, especially because of the amount of pro pers. They need to know what is final. And so that amended judgment is a judgment under 78A, and it has to have some finality under 78B or C for it to be enforceable. Because at the end of the day, enforcement is what, is the key thing here. We have all these monetary type cases. We have parenting type cases. If I go into let's say I have a motion to amend that changes custody, decision making, or whatever you want to call it, and I go now register that in a foreign state under the UCCJEA to try to get a warrant to take the kids. It's not a final order.
Well, Counsel, let me ask you this question then, because I understand that the way you're approaching this, and the argument before us that you're starting with, in order to be able to appeal, it's got to be on either a 1201A1 or 1201A2 circumstance. I'd like to start at the other end, though. Why don't we start with looking at the particular order here and see if it can fit within the definitions within Rule 78. And then if it can't, I'd like to know why. So the particular order here, it was a written order. And if it adjudicated at least one claim or defense, then it would be a decision under 78A2. And that type of a decision within 78A1 seems to be then considered as a judgment, a decision resolving any petition listed in Rule 23A. So couldn't we approach it from that angle to then say in the first instance, well, it is a judgment, and then determine which provision under 1201A it should fit? And if there's a problem with that, let me know.
No, and I think, I guess I'm looking at it as, what finalizes the case? And, when is the appropriate time to say no further matters remain pending? It really is, that's when the true answer is that this is no further matters remain pending, when that final order gets entered. Because it's literally what, we typically file the notice of appeal based, well, we should be filing the notice of appeal based on. And you basically, to go along with your argument, Justice Montgomery, that
well,
that would
just
have
a question. You get to argue.
Well, I understand. The statement you made was you'd have to assume that it just got subsumed into the original order or decree or whatever it was, and so that the decree finalized it or had enough language under 78B or C. The problem is, again, trying to explain that to the 92% of cases that don't have lawyers on them in Maricopa County is what is final, because the judges always put the additional language, this is the final appealable order, you can, the time to run does this and the standard minute entries. And I think that's the problem, is no one would know what that is.
Well, a lot of what you're talking about are good arguments, I think, for maybe changing the rules. And we're always trying, it seems like we're always fiddling with these rules to try to make them easy for anybody to be able to understand, and points taken on some of the things that you're raising. I'm more interested in how the rule is currently written, and in this scenario, that the record that we have it in your case, if it meets the definition one of a judgment. I mean, is it appealable in and of itself? And perhaps if you could address Rule 78A, as I looked at it, this certainly isn't, the ruling isn't a judgment in terms of it's a decree of dissolution of marriage itself, that kind of thing. So you really get down to a decision resolving any petition listed in Rule 23A or any post-judgment petition filed under Rule 91B is a judgment. Certainly it doesn't say anything about Rule 83, a motion to alter or amend. So you're down to, is this a decision resolving a petition listed in 23A? And why isn't it just as simple as saying this was an order that addressed a motion to alter and amend? It didn't address a petition listed in 23A.
Well, I think that, again, at the end of the day, it did resolve the petition. It was the final order resolving the petition, the decree, or what the underlying case was. This is the final order that did the decree. I mean, we could start going down the line of what if the original decree didn't dissolve the marriage and they granted a motion to amend that dissolved the marriage. And because it didn't include that one sentence, it didn't include one jurisdictional statement. And so trying to discern that a motion to amend that added the words that's ordered dissolving the party's marriage, or finds that the conciliation provisions under 381.01 were not met or were met, but it granted a motion to do that. The splitting hairs of trying to find what the final order in this case is what causes the problem. This is the final order to resolve the petition.
And then if that, sorry to interrupt on it, but I know your time is going down. Where does it end? I mean, you can file a motion for reconsideration, a motion for clarification. There's all kinds of motions that people file. Why can't they make the same argument? Well, that was the last thing that happened, and this is the last thing the court ruled on in resolution of the petition.
Well, I think that that RCAP 9 covers that, because those aren't time extending motions. And so this is the final time extending motion that's allowed under RCAP 9. I mean, if you file the motion to set aside within the 25 days, that's allowed too. But a motion to clarify and a motion to reconsider are not time extending motions under RCAP 9. So those are, like a motion to set aside is a perfect example what an A2 order potentially is, because it completely raises different grounds than what you're appealing just out of the decree. There's newly discovered evidence or something. It's a completely different ground. So it meets the Arvizu test of that it's on a different ground than what the underlying appeal. Most motions to amend are on the exact same issue that they fought about at trial. I mean, it's just, you got the, frankly, it's like, Judge, you got the law wrong. Can, read this case again and you'll rule in my favor. But a motion to set aside, especially for, fraud upon the court or something down the road, that is an A2 because it's on completely different grounds. So that fits Arvizu. But here, where you've got, this is just the final order, and the multitude of ways that these motions to amend fix decrees, and to try to split that, let's say it doesn't have a jurisdictional statement. Well, then is it a decree under 78A? It can't be. It doesn't state all the jurisdictional grounds to make it a decree. And so that's why that the only way you can read this in our position is that the ruling on the motion to amend, granting it, denying it, whatever it is the final part of the judgment. That is when the judgment is complete, whether it amends it or not. Here it obviously amended it. It added a bunch of additional factual findings. That is the final judgment. It's just because the court could theoretically have a decree, I rule for dad on all issues. Let's say that was the divorce decree. I rule for dad on all issues. And you file a motion to amend saying, well, that's not enough. You need the jurisdictional statements, you need child support, you need to address property. But if that, then they issue a one sentence, I rule for dad on all issues as stated in his pretrial statement. No one's going to think that that's a legitimate decree. Let's say it's assigned under 78B or C. You file a motion to amend and say, well, please go through the actual statutory requirements that are required under all the custody statutes and so forth. If that next one has it, it's going to be hard to think that that is not the actual decree or judgment. And that's where I think that trying to split hairs and be so very specific about how much was amended or how much wasn't amended, at the end of the day, the final judgment is that ruling on the motion to amend. It is the additional findings, because they add jurisdictional stuff all the time. We've had them like leave out kids, that they ruled, or we've had them where they included kids that weren't in the parties. They gave custody to some random kid. And so obviously that's like not joking, but it's, so those things, the final judgment, let's say they left out a kid. How could the original decree be a decree when it left out a child?
Well, Mr. Berkshire, let me bring you back to what you said about three or so minutes ago about when I asked you about the motion for reconsideration or other motions, you said, well, those aren't time extending motions under RCAP 9, and they're not. What difference does it make under RCAP 9? That's simply saying that the time is not going to run on a judgment. If certain motions are filed, this will extend your time. I'm not seeing the connection between why does that then make a difference under Rule 78 that somehow now it's a new judgment.
I think it makes a big difference because obviously you need finality in all these cases. And so the need for finality and why RCAP 9 exists and what is time extending and what isn't time extending is because we want these people to be divorced, on custody orders to be entered. We want final judgments to be entered. So obviously if you file a motion for fraud upon the court, 6 years later, which you can, that we don't need everybody held up until that point. So I think RCAP 9 protects that we want to enter these promptly and we want to know when the case is over, except these certain exceptions like Rule 85 of, something else happened. You found out fraud later, hidden evidence later, or so forth. But those would fall under A2. The importance is that the reason I think those are different is because those are the rare exception versus just what is it, extremely common practice and extremely common that's contemplated by the rules, why it has such strict deadlines of 30 days or 25 days under Rule 83, and why that's important, that finalizes in a prompt way. And so I think it is a big difference in what is contemplated by the rules and the statutes of, what we know is final. And again, these motions to amend, the amount they're used and the orders are used in family court really can't be overstated because they are used all the time to correct all kinds of things, to change judgments and support orders all the time. And again, a lot of times they enter completely new decrees and do strike-throughs on these decrees where, what is that? If it's a completely reissued decree, it is a decree, it's a judgment, it finalized the case. And then I'd like to take my last 3 minutes.
Thank you. Okay, Ms. Humphrey.
Oh, you're taller than me. Thank you. Isabel Humphrey, Your Honor, from Aspey, Watkins and Diesel, and I'm here with Mike Wozniak, and our client is also here. I'm not sure if we're here on a rule change petition or on an appeal, but
Well, Counsel, if you're going to start with that.
yes, absolutely.
I think you've got a little bit more time to go, Bo.
Pardon?
Please continue.
Okay. Honestly, I understand the wish to have everything clear and simple and easy to follow for the unrepresented people in the rules. I'm not sure we're on the right path to that, but I know everybody's trying very hard. And the problem here is the place that the confusion arises is not so much in the rules, but in the statute, in the jurisdiction statute. So in ARS 12-2101, Part 1 says a final judgment is appealable. Part 2 says any special order after final judgment is appealable. And then there's a whole list of like 8 or 10 other items. And then there's a couple things scattered in other statutes as well. That kind of thing, you can't necessarily clear up all the confusion through court rules because you don't have the power to clear up all the confusion through court
Thank
rules.
you for saying that they screwed it up rather than us.
Absolutely. It's not your fault. And I'm just coming here to tell you that. But here's the good news is although there has been some chaos in the family court rules over the last 10 or so years, the way it's written now, although it's not too similar, the way that's Rule 78 of the family court rules is now written, although it's not very similar anymore to Rule 54 of the family court rules, the outcome is actually very much the same as to the issues we're talking about here. The actual issue before the court today is very simple and non-controversial, which is when you have a final judgment that everybody agrees was a final judgment with Rule 78C language, which was the decree of dissolution, January 21st, 2025. And then there's a proper, timely, time-extending Rule 9E motion that's filed. And then there's a signed written order that disposes of the Rule 9E motion. Does that start the appellate clock running? And the answer is yes. Rule 9E says yes. And so that's when your 30 days starts. And in this case, that was May 5th. So the 30 days ends June 4th.
So conceptually, what does happen to the changes that are made in the denial of the motion to amend? Do they become retroactively part of the final judgment? Do they become non-appealable?
No.
Especially if they're substantive. What does happen to them?
If there's a denial of a motion to alter or amend, as there was in this case, and if hypothetically there had been something in the denial that you could appeal because it was an issue that was different from an issue that would have been raised in an appeal from the original decree. So something that lands under our visu. If there had been hypothetically something of that sort in the denial of the motion to amend in this case, then Rule 9E tells you that you have 30 days from a signed written order that disposes of that motion to alter or amend. You have 30 days to appeal whatever's appealable within that decision. And that decision falls under ARS 12-2101A2, a special order after final judgment.
So would the underlying judgment and the Rule 83 ruling be appealed in the same appeal, assuming that the Vincent standards met under A2?
That was the hope and point of that rule change, which was 100 years ago or when, no, I'm sure it was 30, but it feels like 100. So yes, that's the point of it. Yes. So you have your time extending motion, and when that is disposed of with a signed written order, you can then appeal the underlying judgment, and you can appeal anything new, and that's under 12-2101A1. And then you can appeal anything new in the ruling on the motion to alter or amend or whatever you filed under 2101A2. And you have the same time running for both of them, 30 days time. It's the same under civil rules, family rules, whatever you're doing. It's that Rule 9E has been working very well and is working as intended.
And so would appeal then of the Rule 83 ruling
Right.
would be foreclosed under A2 only if the issues were subsumed with the underlying judgment? In other words, there's no prejudice.
Right. It would either not be appealable because there was nothing appealable in that order, or it would be appealable, and then you have your 30 days from a signed written order, which Rule 9E tells you, signed written order. And all the case law tells you that, I think there was actually an Arizona Supreme Court case. I think it's in re Vincent. It was about 10 years ago. And in that case, this court said, when you have a ruling on a Rule 85 motion, I believe it was in that case, when you have a Rule 85 motion that is decided, that ruling is a special order after final judgment, that you have 30 days to appeal under Rule 9E, under ARS 12-2101A2. It's a special order after final judgment. This part of the Henry Vincent case, this wasn't a surprise to any. I hope I got the name right because I'm just pulling it out of my head, but I think it is.
Vincent v. Shanovich. Very
so this is a non-controversial concept that these decisions on the motions to amend, on other time extending motions, that you have 30 days from the ruling if it's a signed written order, as it says in the rule.
Counsel, may I ask you the same question I asked Mr. Berkshire, that what if we start at the other end, though, and didn't the order here, can it fit within the 78A2 definition of a decision, which then would constitute a judgment in 78A1. Why?
You have to
Why
look at-
wouldn't that work?
You have to look at the definition of judgment in 78A.
Well,
And
but
that-
it doesn't work that easily. Because if you look at, yes, we can look at the definition of judgment, but in the second sentence, it also says a decision resolving any petition listed in Rule 23A is a judgment.
Right.
Well, and then we go down to A2, well, what's a decision? Decision is used in this rule as a written order that
Yes.
adjudicates at least one claim or defense.
But
So-
this is not a decision that resolved a petition listed in 23A or in
So
91.
it didn't resolve any of the issues that were raised in the motion to alter or amend from
It
the
did.
decree. That's.
It did, but it did not resolve a petition. And this, honestly, this works very similarly to probate court, if any of you have practiced in probate court. There are petitions in family court and probate court, many petitions, they get resolved with final judgments at this point, and you have multiple final judgments in family court and probate court because of that, because there's petitions and there's successive petitions, and you might end up with 5 judgments over the course of 15 years. But no, in this case, it was not a resolution of the petition. The petition for dissolution of marriage was resolved with a Rule 78C judgment on January 21st, 2025. And then there was a time extending motion, which does not fall under Rule 78A. And if it did, it would conflict with the statute, so we don't really want to do that if we can help it.
But let me be clear here so I understand what your argument is that my question didn't address the nature of the motion. A decision is used in this rule, again, 78A2, is a written order that adjudicates at least one claim or defense. So nothing about a motion.
Absolutely. I think this was a decision, absolutely,
Okay.
but it's not a judgment.
So, and then 78A2, a decision, and if the argument is that, well, it really didn't resolve anything, then I understand that. But that decision then, as defined in 78A2, would be a decision resolving any petition listed in Rule 23A. That's a judgment.
Your Honor, the ruling on the motion to alter or amend is certainly a decision, but it is not a judgment. It did not resolve the petition. The petition had already been resolved in a final judgment.
Okay, so the argument then is because it didn't resolve, it can't be a decision that constitutes a judgment in 78A1.
It wouldn't be a decision that constitutes a judgment. It would be a decision, certainly. And in the civil rules, in Rule 54, judgment is defined as any appealable order, which would include all of these special orders after final judgment. But then in 54B and 54C, instead of saying to make a judgment appealable, you do the following, which is what the family court rules say. It says to make a judgment final, you do the following. And so in the civil rules, they define judgment in a way that would include 122101 A1 and A2 decisions. But then they say, here's how you make it final, which means it only applies to the 122101 A1 decisions, which have to be final for you to appeal them. And in Brumette, they went through this very carefully in the 2016 Court of Appeals case, went through every subsection of that statute and some other statutes and said, this one requires a final judgment, so you need 54B or 54C language. This one doesn't require final judgment, so you don't need that language.
So counsel, just to clarify from my understanding, if the original judgment is incomplete, it's deficient in some way, it doesn't have a jurisdictional statement, the example that opposing counsel was setting forth, that still, in your opinion, is the judgment, and the subsequent ruling completing it is not a judgment.
No, it would not be. I mean, I don't think that you can have a decree of dissolution with Rule 78C language and just say, you know, I don't think this is valid because it doesn't have a jurisdictional statement. Therefore, the appeal time doesn't begin to run. That is going to create some serious chaos. And I don't think it's consistent with the statute, which is what we have to, ultimately look back at is what does the statute say, and are the rules consistent with the statute? So no, I don't, that would not be the decision clarifying or completing the judgment would not itself be a judgment unless the judge makes an amended decree or an amended judgment.
What about here, I thought that maybe the judge here might have inserted some confusion into the process by, in the ruling on the motion to alter amend, the first one used the Rule 78B language, and then in lifting the motion or lifting the stay on execution, then put in the 78C finality language, which, if I understand your argument, neither of those were required to put in any type of finality language into the judgment, which seemed to have misled, frankly, a little bit of this. So I kind of feel for
I don't disagree.
the parties here. One, can you just clarify, did the judge appropriately mention those rules in the orders? And two, if the judge didn't, is there any pathway for relief here because of the confusion inserted into those orders?
I don't believe there is, Your Honor, and that's because it's a jurisdictional issue. And so, you can't get out of it through excusable neglect or confusion or whatever the situation is. I believe if you go back and look at the record, I don't know if it'll make you feel any better, but I do believe the judge was asked to add that, to include that language, at least the second time. I'm not sure about the first time, when she put in the 78B language. But
was there any necessity to do that?
No.
Yeah.
No.
I would think you would just say denied, and
Right.
maybe with your explanation, but I didn't see a need to go into that if I understand.
Absolutely. And I do think that there has been, because the family court rules changed, I think they changed in 2018 and then in 2022. They keep changing, and I think that there is some difficulty in landing in the correct place. And I think a lot of the judges just feel like there's no harm, no foul. I should just throw this language in, whenever I'm asked, because maybe it's important. And so they want to do that, if they're asked to, because it might be important.
So
but I think Rule 9 is clear on how this works.
So do you view in the May 5th order, the 78B language, do you consider it to be some sort of like a legal nullity, null and void, just simply of no effect, no impact?
Of no effect, I would say yes, because there was a final judgment, and this is a ruling on a time extending motion on a final judgment. So there's no need for that language, but there's no need for all the language explaining your ruling either. I hate to call it a nullity, I think that the judge is putting in things that she thought might be helpful, and it just, wasn't necessary to trigger the appeal time, which you can clearly see. The one rule here that is not confusing at all is Rule 9E. And it says, look, you file one of these motions, that tolls the time until you get a signed written order. So you have a signed written order, that starts the time.
You, in responding to one of Justice Montgomery's questions, as I understood it, you said that to read Rule 83 into Rule 78's definition of judgment, and whichever way you would get there, presumably from the language, a decision resolving any petition listed in Rule 23A, you said that it would conflict with the statute.
Oh, yeah.
Would you elaborate on that point?
Yeah, well, for one thing, you have two subsections right at the start of that statute, 12-2101A1 and A2. A1 says a final judgment is appealable. A2 says any special order after final judgment is appealable. So what you would do, I guess if you're only doing it as to family law cases, you're also creating a big conflict with civil law, which is unnecessary. But if you say all of these special orders after final judgment also have to be final judgments, then you're merging those two subsections of the statute. And so you're saying, subsection 2 doesn't really mean anything if there's a special order after final judgment, it's still not appealable unless it actually fits within subsection 1, unless you make it a final judgment. Are there other questions? I have in my notes to say in Brumette, which I don't believe they had any family law cases. They consolidated, 15 or 20 cases to talk about how the statute works. And I don't believe they had any family law cases. But paragraph 15 in Brumette, they did say the special order after final judgment obviously doesn't itself have to be a final judgment. And then they dropped a footnote to say that would write out of the statute subsection A2. Then you wouldn't have any special orders after final judgment. It would all just be final judgments.
One final thought I had, in your view, does the Rule 83 motion operate any differently than the Rule 59 motion on the civil side? Are the way that these rules drafted, are motions to alter an amended judgment treated any differently on the civil side from what you've described?
No, I don't think so. And it may be that they would have been under some prior iterations of the family law rules, but I think now the way that it has all come down the pike, I think even though Rule 54 and the other civil rules regarding post-judgment motions and Rule 78 and the other family law rules, the operation of them turns out to be the same. And all you have to do is follow Rule 9 and say, okay, I have my judgment, I have my time extending motion, and when that's decided and assigned to order, my appeal time starts.
And same with probate?
Yeah, same with probate. Yeah. And it's just the only wrinkle is in probate and in family law, now you have multiple judgments per case usually because you're going to have more than one petition. Thank you.
Thank you. Hey, Mr. Berkshire.
I agree with counsel on a lot of what she said here. The problem is just her reading of A2 is wrong on what our visu says. Our visu is very clear that for it to be under A2, this order has to be appealable somehow. Like the motion to alter amend order has to be appealable. They change all kinds of things in it, in these all the time. So it has to be appealable. But our visu says specifically the issues raised by the appeal from the order, meaning this post-judgment order, must be different than those that would arise from the underlying judgment. They're not. You file a motion to amend saying, Judge, you ruled wrong on child support because you did X, Y, and Z. It is by definition, not different. They are identical issues. And look at what our visu was. It was a post-decree attempt to change paternity. Our visu was a family law case. It was a post-decree attempt to do a DNA test years down the road after the decree. And they said, you could have done that already at the original thing. So it's not a different order.
Well,
a motion to amend.
I agree with you on that. But one thing I haven't heard you say is that at least my understanding has always been that a motion to alter and amend brings up something, you should say, that was already adjudicated. You're just asking for something different in the judgment. But then on appeal of the judgment, you can still bring up all the arguments that were made in that motion to alter and amend. So in effect, the motion itself is subject to appeal. You don't need it to be a special order after the judgment in order to make it subject to an appeal. The issues are raised in there. It just comes up on the appeal of the original judgment.
Correct. I think that's true. And I mean, most people put in the notice of appeal. I'm appealing both just because for procedural.
Right. So what's the you seem to be saying that this is falling within the cracks somehow, so that rulings on these motions aren't subject to appellate scrutiny. And it seems like they are, either under the appeal of the judgment, or if they themselves are a special order, they're separately appealed.
Well, they can't be a special order because they are literally the identical issue. You're saying, Judge, you interpreted blah case wrong in your decree, and even if they deny it, you're appealing the exact same order. I agree. Rule 85 motions down the line are absolutely a special order after judgment that would fall under A2. But a motion for new trial, just saying you got the case analysis wrong, is not. It can't be. It's literally the same type of thing. And I think it goes exactly to what Justice Montgomery was saying about the 78A2 question of when this is resolved. That is the issue, is what resolved the underlying petition under 23A. It is the order on the motion to amend that resolved the petition. That is the final order that is the judgment, especially if they change anything in it. That is what resolved it. That is what the final language of the order is, are these additional findings, especially when they change money. If you changed from $1 to $1 million, you can't say that $1 million isn't what the resolution is. It is the resolution. And that is the final order on the underlying Rule 23A petition. That's the order that finalized the case. Unless it's a special order after judgment, which these aren't. Those are exceptions. They're Rule 85 exceptions. They're exceptions down the line post-decree. A motion to amend is not a post-decree some change that falls under A2. I know I'm out of time.
I know. Thank you, Mr. Berkshire. I thank both counsel for your arguments today and your arguments in the written pleadings and petitions. I will take the matter under advisement, issue a ruling in due course.